What should heirs know before selling inherited property in an HOA? Selling inherited property in an HOA usually requires extra work before listing because HOA dues, special assessments, violations, resale documents, liens, and approval rules can delay the sale or reduce the estate's net proceeds. I'm Rhett Fruitman, co-founder of Inherited Property Match. My background includes private banking at Citi Private Bank and commercial real estate at CBRE, and I help families navigate inherited property sales across the country. This is general information, not tax, legal, financial, or real estate advice. Before you sell inherited property, speak with a CPA and when probate or trust administration is involved, an estate or probate attorney. If the inherited property is in a homeowners association, condo association, townhome association, or co-op, the association rules do not disappear when the owner dies. The goal is to find the right authority, contact the association early, and get the HOA issues clear before a buyer is already waiting to close. Do HOA rules still apply after the owner dies? HOA rules still apply after the owner dies because covenants, conditions, restrictions, dues, assessments, and maintenance standards stay attached to the property. The estate, trust, or new legal owner has to deal with the same association rules the prior owner had to follow. That can include monthly or quarterly dues, architectural standards, landscaping rules, insurance requirements, and sale-related documents. The first step is to notify the HOA or management company that the owner passed away and identify who now has authority to communicate about the property. That often means providing a death certificate and proof of authority, such as letters testamentary, letters of administration, a trust certification, or other estate paperwork. Authority to talk to the HOA is not always the same as authority to sell the property, so confirm who can sign listing documents and sale contracts before the property goes live. Who pays HOA dues and special assessments after death? The estate or trust usually pays HOA dues and special assessments while it owns the property, and unpaid HOA charges are often paid from sale proceeds before heirs receive distributions. Heirs usually are not personally liable just because the deceased owner owed HOA charges, but the property can still carry unpaid dues, fines, assessments, interest, collection costs, or liens, and anyone who becomes the legal owner may become responsible for ongoing association obligations. Ask the HOA for a current account ledger early. The ledger should show regular dues, unpaid balances, special assessments, fines, late fees, credits, and collection activity in one place. Special assessments are a common surprise. If an assessment was approved before death, the estate or trust may need to address it. If a new assessment is approved before sale, responsibility depends on state law, the HOA documents, the assessment date, and the purchase contract. What is an HOA resale package? An HOA resale package is the set of association documents, disclosures, financial records, and account information that buyers, lenders, brokers, and title companies may need before closing. A resale package may include the CC&Rs, bylaws, rules and regulations, budget, financial statements, reserve information, insurance certificate, account status, pending special assessments, pending litigation, rental rules, architectural rules, and association contact information. State laws vary. Some states require specific resale disclosures, delivery deadlines, and buyer cancellation periods. Other states leave more of the process to the governing documents, the management company, the contract, and local closing practice. Request the resale package as soon as the decision to sell is made. Waiting until the property is already under contract can create avoidable closing delays. What HOA fees and liens can reduce sale proceeds? HOA charges can reduce inherited sale proceeds and unpaid dues. Fines or special assessments can become liens that the title company may require to be paid before closing. Can an HOA lien stop a home sale? An HOA lien can delay or block a closing until the payoff, release, estoppel certificate, or settlement instructions are resolved. Common HOA-related closing costs include resale package fees, transfer fees, estoppel or status letter fees, compliance inspection fees, document processing fees, and sometimes capital contribution or working capital fees. The amount varies by state, association, management company, and governing documents. The practical move is simple. Ask the HOA and title company what must be ordered, what it costs, who pays it, and how long it takes before the listing goes active. Can rental rules, right of first refusal, or buyer approval slow the sale? Rental restrictions, right of first refusal provisions, and buyer approval rules can slow an inherited HOA sale by shrinking the buyer pool and adding association review time. Some communities restrict short-term rentals, long-term rentals, investor ownership, or leasing during the first year of ownership. That matters if heirs plan to rent the property while deciding what to do, or if investor buyers are likely prospects. A right of first refusal, often called ROFR, means the association or another party may have the right to match an offer before the sale moves forward. Some condo associations and co-ops may also require buyer applications, board approval, interviews, or document review. The listing broker needs these rules before pricing the property, marketing to investors, or promising a fast closing timeline. What HOA violations should heirs fix before listing? HOA violations should be fixed before listing when they are small and disclosed or negotiated when they are material. Common inherited property violations include overgrown landscaping, exterior paint issues, trash or storage problems, unapproved modifications, deferred maintenance, satellite dishes, fencing changes, parking issues, and architectural work that was never approved. Vacant inherited homes can attract extra attention because small exterior issues become visible quickly. Ask for the full violation history and any open compliance letters before photography, showings, and buyer inspections. Minor issues like landscaping or cleanup are often worth fixing before listing. Major issues such as unapproved structural changes, encroachments, or exterior alterations may require association negotiation, contractor estimates, title review, or buyer disclosure. What documents do heirs need before listing an inherited HOA property? Before listing an inherited HOA property, heirs should gather the HOA documents, estate authority papers, and current payoff information needed for title, buyer review, and closing. From the HOA, gather the account ledger, resale package, estoppel letter or account status certificate, violation history, rental rules, right of first refusal rules, buyer approval rules, pending special assessments, and management company contact information. From the estate or trust side, gather the death certificate, letters testamentary, letters of administration, trust certification, deed, title information, and proof of authority to sell. Depending on the title and probate status, the seller may be an executor, personal representative, trustee, surviving joint owner, or other legal title holder. In some probate cases, court approval may also be required. Selling inherited property in an HOA is manageable when the HOA is contacted early, association charges are budgeted, documents are ordered before the buyer appears, and authority to sell is confirmed before listing. If you inherited property and need help finding a broker who understands estate-related sales and HOA issues, Inherited Property Match can connect you with a vetted broker experienced with inherited property. The match is free.